Every long story eventually arrives at the same place, the moment when silence runs out of time. For years, according to the filings described in this series, allegations circulated within an environment that continued operating almost unchanged. Complaints were raised, concerns were discussed, authority structures remained in place. The lawsuits that now exist do not describe a single moment of exposure. They describe accumulation. One report becomes two. Two reports become patterns. Patterns become cases filed in court. And once allegations move into legal filings, they leave the private world of institutions and enter the public record. That is where this chapter begins. Because courts change the landscape. Inside an institution, authority decides what is investigated, what is contained, and what remains internal. Inside a courtroom, the structure is different. Evidence becomes a matter of record. Statements are made under oath. Claims are tested through legal process. The story moves from internal management to external scrutiny. That shift is what the lawsuits represent. They are not conclusions. They are the beginning of a process designed to examine the claims themselves. In the filings connected to the allegations discussed throughout this series, plaintiffs describe experiences that span years. They describe environments where authority remained constant, while warnings, concerns, and reports accumulated around it. The defendants named in these lawsuits deny wrongdoing, and that denial matters, because the legal system exists precisely for that conflict accusation on one side, denial on the other, evidence presented between them. What happens next is no longer controlled by administrators, leadership committees, or internal conversations. It moves into depositions, discovery, and the formal testing of claims. Documents may surface. Witnesses may testify. Chronologies may be examined in detail. And in many institutional cases like this, the central question becomes surprisingly simple. Not just what happened, but who knew and when. That question echoes across many scandals that have come before. Because institutions are designed to endure, they protect reputation, they preserve structure, they resist collapse. Sometimes that stability is strength. Other times, plaintiffs argue, it becomes a shield, a way to absorb allegations without fundamentally changing the system that allowed them to occur. This series has followed the progression described in the filings. First, a report minimized, then warnings ignored, then an environment described as protective of its own structure, then allegations that awareness existed. Now the story enters its final stage. Public examination. The lawsuits do not determine guilt. Courts do not operate through narrative alone. They operate through proof. But lawsuits accomplish something else. They bring allegations into daylight. They transform private claims into public questions. And once those questions are asked publicly, institutions cannot answer them quietly. That is where this story now stands. Between allegation and judgment, between accusation and denial, between the past described by plaintiffs and the outcome that only legal process can determine. Whatever that outcome becomes, one thing is already clear. The story is no longer contained. All allegations described in this series are drawn from publicly filed lawsuits, sworn statements, and court records. Defendants deny wrongdoing unless otherwise noted. The courts will determine what comes next.